Hi, all. Today's class is about regulating police behavior, a key part of constitutional law at the Supreme Court, looking at the criminal justice area. In many ways, the key case that kicked off much of the debate in the 1960s about the Warren Court was when, in Mapp v. Ohio, the exclusionary rule, the idea that evidence collected in some illegal, unconstitutional way could not be introduced in court, was applied to the states. This was a case where there was an apparent debate over an unconstitutional search of Miss Mapp's home. Now, the important part here is the exclusionary rule was not new. It had existed for federal cases since as early as 1914. The debate for decades had been whether the same rule applied to the federal government would be extended to the states. And for a long time, the court had said no, they're going to let the states have their own rules. Federal constitutional rules on this would, and the Fourth Amendment would apply only to the federal government. Mapp v. Ohio changed that. This was a case, an interesting case with a lot of details that are worth exploring in the supplementary materials. But the key was a bombing suspect. The police thought Miss Mapp was hiding them in some way. And they approached the home, asked to search. While they waited, Miss Mapp called her lawyer, who was on speed dial of some kind. Um, Notably, this was an African American woman in the early 60s, so was not your average person of any race, but was obviously very interesting within a whole community that a lot of folks understood might be targeted in a discriminatory way by the police. Now, they ended up searching the home with no search warrant, but the Ohio Supreme Court said that's okay, they'd uphold the conviction. So the question was, would the Supreme Court second guess Ohio's own Supreme Court to enforce the right? And the majority said that they would. And the reason they did is worth looking at. The important thing throughout this course is not just the decision made in the cases, but the debate between the majorities and dissents on what's at stake in the case. And the majority said, look, basically, we control the courthouses. And if somebody else violates constitutional law, we're not going to allow the evidence allowed. And essentially, if they don't withhold like that evidence, the message in the majority said, quote, we need to compel respect for the constitutional guarantee in the only effective way we can, essentially, by removing the incentive to disregard it. They don't also want games played at the state level with different rules from the federal government. And there was this general emerging idea of protecting areas of, quote, personal privacy. Now, the dissent basically was like, look, most states don't agree with the exclusionary rule. Why are we imposing this on them? You know, they also note that the exclusionary rule only helps the guilty. If you're innocent, it doesn't help you since, yes, you can protest having an illegal search, but since you're never going to trial, you have no rights to prevent it. So there were a number of different debates on this, which are worth looking at as you go through the case. Now, some of the other cases that mattered in all of this, to even have a warrant, you need what's called probable cause. And the courts over time would move to looking at what they called a totality of the circumstances approach, trying to debate what's at stake. Are you searching a home, a car, a person? What was the information you had? And it became a very fact based decision making on whether a warrant was justified or whether the police might be justified on doing a search even without a warrant. For example, the text discusses the case Maryland v. Pringle, which was a police stop a car with passengers, including Pringle, who was the front seat passenger. Now, the police see a lot of rolled up money in the glove compartment and ask to search. The driver gives consent and finds that there is quite a bit of cocaine near Pringle. Pringle later admits that it was his cocaine, but he basically protests that the search shouldn't have happened since he didn't give consent to the search. The thing that the court says, and they're looking again at this totality of the circumstances, saying, look, everybody's going to the party together. They seem to be in the sort of same endeavor, they argue, that there is the idea that you have to look at why people are together to decide whether you can search, say, a whole car or a whole like room. They contrast this with Ybarra v. Illinois, which was a case where patrons were all patted down at a bar. Now, they said that, look, just because you're at a bar doesn't mean the owner of the bar can give permission to have everybody searched. Because you go to a bar, you're not necessarily friends with anybody else and definitely not necessarily friends with the owner. Sharing a car in this argument is different. It's more like being together. You might be actually going to the party together. The money might be collective, the drugs might be collective. At least that's the argument here. The other issue is not just can you search, but what about arrests? What are the circumstances when you have the right to arrest somebody? Because there is the use of arrest warrants. Not always. Sometimes people are arrested just on the fact that the police observe a crime in process. What they argue for is that there has to be some basis for it. And often, this is a critical part. Once somebody's arrested for any reason, there have been other cases that said they can then have their bodies searched incident to the arrest, sometimes searching a car, although the whole case law around when you can search a car after an arrest, where you can search, is quite complicated. But here's the interesting case had you read, which was Atwater v. City of Lago Vista. This was the question of, is arrests themselves a form of constitutional violation, especially if, as in this case, there's no potential prison time if you're arrested, which means the arrest itself, the time you spend in jail, is more than any jail time you'd have gotten if you were just given the ticket and convicted on the spot. In this case, the police approached a driver that they seemed to have known before, that had apparently been driving around without seatbelts before, and said, again, you're not using your seatbelt. Ended up arresting the woman, had her kids taken home by a friend. Atwater, the defendant, was arrested, booked, and released on bail. Now, the district court and the full court of appeals upheld the arrest as lawful, and the question was, would the Supreme Court uphold this as well? Now, what's interesting about this is both the majority and the dissent argue less whether the police officer was justified. They both basically say that the officer was acting in a vindictive, capricious, pretty nasty way. But the question was, and this is where it's a bit like they have William Stuntz in mind, how will other actors use whatever decision they make? Justice Souter in the majority says, look, there's all sorts of ways to look at this. We have to instead look at the question of the state, in its infinite wisdom, had said, yes, we are having seatbelts not on you a misdemeanor. They specifically said, if you can be arrested for this in jail. They put that into the statute, so that part was unclear. So to actually strike down the right to arrest them, they'd have to overturn what the court or what the legislature had said. And he does note one important thing. If you allow Atwater to go free, saying, oh, There was no prison, no jail time attached as a punishment. So anytime a misdemeanor has no jail time attached, we can't arrest them. What's the legislature likely to do? As Souter said, the likely response might be to pile on more jail time to minor cases just so police would have the power to arrest, which might create the quite almost ironic result of increasing criminalization by trying to give them rights. So, in this sense, Souter seems to be reacting. Remember, this is 2001, many decades after the Warren Court, to the kinds of insights like William Stuntz had that whatever the Supreme Court does, legislatures might act to subvert it. But in dissent, it's worth noting that Justice O'Connor, often no friend of defendants in this court, notes the part that if you give people the right to arrest for minor purposes, minor crimes, the likely result will be to give the police the ability to harass people through gratuitous arrests. You know, notes about the unbounded discretion of police leading to abuse. I mean, there's a certain amount of understanding. This is happening in the context, as we'll talk about more in future classes, of, you know, people being arrested while called driving while black. There's a lot of racial profiling that's well known in the news and to the court itself. And O'Connor notes if you give this ability to arrest on minor areas, you're just going to expand that problem. It's a hard debate because it can go either way. Each side is less arguing for the substance of the right on high principle and more how does court action feed into other responses by other actors, whether the legislature or police themselves. Okay, so the last major area here is what happens when you search a person on the street. The courts have been very strong in saying if it's somebody's home, they're going to generally require a warrant. It's a very high bar to get the right to search a home. To search a car, it was more in between, but for a person, the court essentially in a case called Terry v. Ohio, and this is the origin of stop and frisk as the debate is, but this was with very specific facts, and it's worth reading the case for those facts to understand when a stop and when a frisk were allowed and when they weren't under the Constitution. We'll come back to this in the follow-up class. But Terry v. Ohio had a description of officers observing two men at a street corner acting in a suspicious way. They think a crime is about to happen. They approach them. They stop them. They tap the outside of their clothes and feel the shape of a pistol, find the pistol, arrest, and want to use that as evidence. Now, when it gets to the Supreme Court, the court is actually relatively clear that A, a stop is a constitutional violation, but where there is strong understanding, the expertise of the police, the fear of a crime in motion, they give the right to stop and frisk the defendant. Now, they recognize there are constitutional worries here, but they were trying to create, at least in their mind, very high standards for when that stop, when that frisk could happen. And the question would be in follow-up cases, what happens if the expertise of the cops was not as high, whether the suspicion of a weapon wasn't really there, and so on. And we'll see those. But this was the original case. So these are some of the broad frameworks of what are the constitutional rights that the court focused on around regulating the police. We're going to talk next week more about when the federal government got involved in saying, no, you've gone too far in various jurisdictions, including New York City. And we're also going to talk about how, as the drug war escalated, many of the rules around search, seizure, etc., would inevitably be weakened to allow the police to go after the scourge of drugs, what was often called the drug exception to to the Fourth Amendment. But, anyways, that's it for today, and I look forward to your discussion.